didn't do what had to be done from a defendant's standpoint. By the way, listen to this. Listen to what the court said and reconcile it with Montgomery, which was a Court of Appeals case 4 years before, or 3 years before. We reject defendant's contention that there is an issue of fact whether the failure of plaintiff to use safety devices that were available elsewhere at the work site, and there were jacks that you could have held up the roof with, that were available elsewhere at the work site, but that were not in place on the roof, was the sole proximate cause of the accident. Why did they reject that? Wasn't that the same thing as in Montgomery? How is this fact scenario any different than that in Montgomery? Anyone? Okay. Here's what the court said. And it illustrates, and I'll tell you something right now, the recent trend is that the courts aren't following the Montgomery decision to the letter. And we all should be aware of that, especially defendants should be aware of that. Here's what the court said. Defendants' reliance on Robinson, which most of you know and I'll discuss in a minute, and Montgomery is misplaced. Here, plaintiff lacked the authority to exercise independent judgment with respect to safety issues, inasmuch as he worked directly under the supervision of two forepersons, neither of whom required or even suggested that plaintiff install roof jacks before beginning to prepare the roof. Well, wait a minute. In Montgomery, this plaintiff who used this bucket to climb up to the motor room and then had to jump down, was a helper. He was working under the auspices and supervision of a mechanic. How did he have the independent judgment to go and get a ladder, which we don't know whether he knew was available or was even available? So what's the difference? None. It's just a way of getting around Montgomery and balance things out, because we are going back now. The pendulum had swung quite a bit in favor of defendants. Now we're coming back somewhat. Now, the next important Court of Appeals case, there's other ones, but these three, Blake, Montgomery, and Robinson versus East Medical Center, decided in 2006, which is at 103, and discussed in detail by Brian at page 46, is a very important case. Plaintiff was installing pipe hanger systems at the job site for approximately 2 weeks using a 6-foot wooden stepladder. He had to climb on it to install rods and overhead beams, and then you hang as those of you who are familiar with these construction work, you then hang the rods from the beams. The pipes would be hung from the rods, rather. At the time of the accident, he was doing the work at a location where the beams were about 12 to 13 feet from the floor, requiring him to stand on the very top of the stepladder. He was using a wrench, it slipped, he lost his balance, causing the ladder to move, and he fell. It was conceded that there were 8-foot ladders available, and plaintiff had told his supervisor he would need one. Never got it. The Court of Appeals affirmed the granting of defendants' motion for summary judgment and the court noted that plaintiff could have gotten the 8-foot ladder himself and held plaintiff's actions were sole proximate cause of the accident. How is this different than Baker? As I said, these cases are very fact-specific. And in Robinson, 1, the plaintiff knew he needed an 8-foot ladder to properly do this job, to safely do this job. 2, he knew, the testimony was clear in this case, he knew 8-foot ladders were on the job site and where they were. 3, his routine was to get tools for himself. 4, and I think this is very important, he wasn't told by his supervisor that he had to do this work right away because there was a question of whether these other ladders were immediately available. He was free to go on and do other work and then come back and do this work. And he had previously waited in this type of situation for a proper ladder, an 8-foot ladder to be freed up. And 1 or 2 hours before his accident is when he had asked for the 8-foot ladder. Now, let's go to some of the appellate division cases that following Blake, Montgomery, and Robinson. I'm not going to go through every case, obviously, in the book. If I went through Brian's, we'd be here 3 or 4 days. If I went through mine, probably a day and a half. But you can read them. I want to go through some of the ones that I think are important and highlight the laws that's evolving. At page 109, you'll find Egan versus Monadnock Construction, which was a 2007 First Department case. Appeal was denied in 2008 by the Court of Appeals, and the court granted defendant's summary judgment motion relying on Robinson Montgomery. As you'll see, okay, I have to move it along. You'll see the facts. You can read them right now because they just tell me I have 5 minutes. Can I have an extra 5?
You have 5 minutes.
That's it? Okay. All right. They rely on Robinson and Montgomery. In Robinson, plaintiff was well aware 8-foot ladders were available and, in fact, asked for them. With regard to Montgomery, the court said the facts are strikingly similar in that ladders were available and is here no record that plaintiff knew a more appropriate ladder available, but it doesn't make any difference. We're going to give him summary judgment evidence, a summary judgment anyway.